Hey guys, it's Anthony Bandiero here, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing a roadside chat. Let's talk about a question from an officer in Tennessee. He says, would the rear of a Sprinter van be treated like the trunk of a car during a search due to the odor of marijuana? On your, for example, on your Search and Seizure show the other day, there was talk about searching vehicles in certain areas with the odor of marijuana. And I also, he's referring to some cases where the courts are pushing back a little bit and saying, hey, you know what? Just because you smell the odor of marijuana does not necessarily mean that you get the trunk of a vehicle. Curious if the rear area of a Sprinter van would be treated the same as a trunk. All right. So, look, let's just kind of set a few rules here, and then we can kind of go from there. So, number one, the odor of marijuana. If you are in a state where it is illegal to have recreational use marijuana, right? Generally speaking, that can provide you probable cause to search the vehicle. However, I don't care if you live in Texas or Idaho. Courts are pushing back on cops just going into court and saying, Your Honor, smelling weed means I get to search the whole damn truck, or the car. They don't like that kind of stuff. They don't like when cops don't articulate what they mean by that, right? So, for example, if this was the 1970s and 80s and maybe early 90s, fine. You would probably see a lot of cases saying go forth. But we see a lot of courts saying, okay, what kind of marijuana are you smelling? Are you smelling like burnt marijuana, raw marijuana, the lingering smell of marijuana, like somebody has smoked marijuana? And I think the courts are just understanding that society is not wanting to be super aggressive on marijuana anymore. That's what they feel, at least, and that's not true in all places. But they understand that, that society has a different view on marijuana. There's decriminalization and deregulation happening all over the United States, even in places where it's still illegal. The courts are cognizant of the public perception of marijuana, like it or not. And number two, they also understand that the smell of marijuana is so pungent that, it could also be that, hey, there was somebody in the car earlier that smokes marijuana, and that's where you're getting that smell. It's not necessarily true that there's marijuana in the car now, and so forth. And another good example is burnt marijuana. We have been able to search cars for decades when we have said we smell burnt marijuana in a vehicle. But now what do you see courts doing? They're saying, well, how do you know it was like during this transportation that they're smoking it, right? Like today, like now, like recently, versus, I don't know, yesterday. So here's an example, right? State versus Cohen, New Jersey, 2023. It says, in cases in which our courts have upheld searches that extended to the trunk or other areas beyond the passenger compartment, have involved facts indicating something more than simply detecting the smell of marijuana from the interior of the car. So when you say things like, when I smell marijuana, I own that car. I get the whole damn car. That is not necessarily true. Let's also look at State versus Curie, 22 out of Ohio. Probable cause to search a vehicle may be based on odors. So it says that by a person qualified to recognize the odor sufficient to establish probable cause. So far, so good. The scope of the search based on the odor is circumscribed, right? Meaning limited, as a trunk and a passenger compartment of an automobile are subject to different standards of probable cause to conduct searches. To search a trunk, an officer must observe more than just an odor of burnt marijuana in the passenger compartment and so forth. So that's Ohio. So you have Ohio, which is pretty friendly to law enforcement. You have New Jersey, which is not so friendly to law enforcement. They're all saying, hey, look, this is not 1976. Okay? The old days is going to court and saying, Your Honor, I smell marijuana, therefore I get to search anywhere I want. Those days are over. Now, applying some of these fundamentals to the Sprinter van. My advice here is that if you do have probable cause to search on the basis of the odor, right, raw marijuana, burnt marijuana, and you see like there's smoke coming out of the car, they tell you they just smoked, while driving, then you get to search the passenger compartment where that evidence could be. As far as the Sprinter van, it's very reasonable to believe that they could have thrown what they were smoking, burnt marijuana. They could have thrown that back into the back compartment of the Sprinter van if it's not separated and compartmentalized. Like maybe there's a cage or something separating the passenger compartment from the back. If there's nothing like that, then generally speaking, that is going to be part of the passenger compartment, because that could be a place where they have the evidence for the burnt marijuana. But if it is compartmentalized, I would treat it like a trunk. So generally speaking, it's going to be a passenger compartment, because most of these Sprinter vans are not compartmentalized. They're just one big open space, because that's how they do business as a utility vehicle. So what are the takeaways? Guys, I have been preaching this for years, okay? And I'm sorry that it sounds like a broken record if you've been following me for a while. But you know how much I love the word articulation. In fact, somebody made fun of me the other day and said that Anthony's favorite word is articulation. So you know how much I love it. I love when you articulate things. I love when you tell the court, Your Honor, it's reasonable for me to believe that the evidence could be an X, Y, Z, and not things like, I did because that's the way I was trained. I've been doing business that way for 20 years, Your Honor. You're the only person that's actually pushed back on me. We don't want to hear stuff like that. We want to be prepared to just describe and articulate why we do the things that we do when it comes to the Fourth Amendment. I hope this has helped. If it has, you know what to do. If you have a question for me, go to bluetogold.com, fill out the show, or join us on our weekly live webinars. We'll answer your questions live in a live studio audience. Until next time, my friends, you stay safe.